Does your mom love you?
Yes, ma'am.
You're breaking her heart.
That's what I'm trying to get this passed. So I can get back to her.
So, but when you say get it past you, you've got to work on it. You got to stop using drugs, because otherwise what will end up happening is drugs damage your body inside and outside. Court is calling 2022 CR 10916, State of Texas versus Carrie L. Henderson. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Todd Lester for Mr. Henderson.
Are you Mr. Henderson?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor, and I have.
Court will find that the state is in compliance with discovery. Mr. Henderson, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Henderson, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
No, ma'am. Yes, ma'am. Yes, ma'am. Sorry.
All right. Did you intend to give up those rights?
Yes, ma'am.
Did you intend to enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Henderson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 1 year in the state jail facility. There are no applications. The state will take in consideration grand jury number 803-269, JN2136760, night mag number 7145598. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Sir, not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State offers State Exhibit 1 and all attachments.
Any objections?
No objections.
State, you may be excused. Mr. Henderson, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Mr. Henderson takes full responsibility. He's pled guilty before this court and wants to put all this behind him. He's very anxious to put this behind him.
All right, the court will find you guilty. The court will take in consideration grand jury number 803-269, JN number 213-6760, NIMAG number 714-598, sentence you to 1 year in the state jail facility and give you credit for any time served. If you would like, I can refer you to the therapeutic community. It does not increase the length of time that you're in custody, but if you have a drug problem, it will help you with that.
Yes, ma'am.
Okay. Now, with regards to the therapeutic community, you'll have to request it as well because I don't have any jurisdiction to force them to place you in it. Do you understand?
Yes, ma'am.
So I ordered the therapeutic community. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this, don't use her thing as your desk. Yeah, that's her office. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
I'm 41.
All right, you're 41 years old. Are your parents still in your life?
Yes, ma'am.
And how old is your mom?
She about to be 60.
All right. Does your mom love you?
Yes, ma'am.
You're breaking her heart.
That's what I'm trying to get this passed so I can get back to her.
So, but when you say get it past you, you've got to work on it.
Mhm.
You got to stop using drugs because otherwise what will end up happening is drugs damage your body inside and outside. You don't want to be that person where there's somebody found dead in San Antonio and people trying to identify the body and your mom learns on social media that it's you. Because the last time you use could be the last time you use. When you go into custody, nobody likes being in custody. And they always say, when I get out, I'm never going to do this again. But then the first thing they get out, maybe they're good for a couple of days, maybe not. Maybe they say, ooh, I'm celebrating, I'm out. The first thing you need to do is go to AA meetings or NA meetings. And if there's anybody in your life who are trying to stop you from going to AA or NA meetings saying, well, you don't have to go today. Let's play some dominoes. You don't have to go today. Let's go hang out at the park. You need to cut them loose because the number one thing in your life should be your sobriety. You understand?
Yes, ma'am.
Do you have children?
No, ma'am.
All right, that's good. Get your life together.
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
The proceeding begins with the formalities. Defendant Carrie L. Henderson, charged with possession of a controlled substance under 1 gram, methodically waives his rights to a trial and appeal. His attorney states Henderson is anxious to put this behind himself. Judge Boyd accepts the guilty plea and imposes the agreed sentence of 1 year in a state jail facility with a recommendation for the therapeutic community program. Just when it seems the hearing is concluding, Judge Boyd goes off the record. She learns Henderson is 41 and that his mother is still in his life and loves him. It is here that Judge Boyd shifts from procedural authority to a figure of profound, stern compassion. She delivers a blow that lands not as a legal penalty, but a personal one. You're breaking her heart. Judge Boyd then destroys any cavalier attitude Henderson might have about getting past this. She doesn't just warn about prison, she warns about the morgue. In a chilling moment of courtroom theater, she describes the potential aftermath of his addiction, being found dead in San Antonio, with his mother having to learn the news through social media. The last time you use could be the last time you use, she states, making the danger visceral and immediate. Her decree is clear. Sobriety must become his singular focus. She orders him to AA or NA meetings immediately upon release and issues an ultimatum regarding his social circle. Anyone who discourages him from attending those meetings must be cut loose. The number one thing in your life should be your sobriety, she commands, blending the force of a court order with the urgency of a life-saving intervention. She concludes not just with a sentence, but with a directive: get your life together. This is Judge Stephanie Boyd wielding her authority not merely to punish, but to attempt to salvage a life teetering on the edge.